Hello, my name is Nichola Warrender QC, and I have the pleasure of welcoming you all to Quadrant Chamber's first hybrid insurance event and introducing our panel of speakers. Whether you're at your desk and watching us online or the select few in our library today, I want to say thank you for joining us. Topics for discussion are centered around the recent decision of Mr Justice Calver in the ZouZou, and Ben Coffer and Guy Blackwood appeared in that case on behalf of the successful underwriters on our panel today. Not only are they both well qualified to discuss that decision, as some of you will know, Guy has a habit of being involved in Venezuelan smuggling cases, having also been in the Atlantic. Davey QC is also on our panel. He is the co-author of Miller on Marine War Risks, and I'm sure everyone will agree that's a very timely publication given what we've been advising on recently. So that's our panel, and the format is that each are going to speak on their chosen topics for about 15 minutes. Trust me, that's the difficult part of the job, and that's why I'm here. And I'll do my best to try and keep them on time. We'll then follow up with questions and answer session. For those of you watching online, if you can submit those questions via the usual way, and Sarah will relay them to my iPhone here, and then I can pick them up and we can discuss them here. I'm going to hand over to Ben now, who's going to kick off by introducing us to the facts of the ZouZou and then deal with the topic of coverage for detention under a typical war risk policy.
Thank you. Well, the facts were reasonably simple. The ZouZou was an oil tanker. She was on time charter to PDVSA performing cabotage. So she's carrying oil products up and down the Venezuelan coast. And during loading, diesel oil somehow found its way into the wrong tanks. The owners said it was a mistake, but the Venezuelan authorities were convinced that the crew were trying to smuggle the oil. So the master and 3 other crew members were arrested, along with some PDVSA employees, and the vessel was detained. The detention was ordered under the Venezuelan law against organized crime, which permits confiscation of assets which have been used as an instrument of crime. And the party can apply for the release of the asset, but to do that, they have to show that they're the owner of the asset and that they weren't complicit in the crime in any way. So eventually, after 9 months, the owners made an application for the release of the vessel, and the vessel was released. And at the time of the release, the vessel had been detained for 14 months in total. The crew stayed in prison in Venezuela for another 3 years and were finally acquitted after that. So the owners had a war risks policy in place, and the war risks policy had a common form of detainment clause within it. And effectively, the effect of the clause is that a detention of more than 12 months is deemed to be deprivation of the possession of the ship without any likelihood of recovery. And Michael is going to talk about the consequences of that and what it meant in this case in a bit more detail in a minute. So the owners presented a claim under the war risks policy relying on that clause, but the underwriters discovered that the vessel had been trading in additional premium areas without telling the underwriters, and they avoided the war risks cover. Our claim concerned the position of the mortgagee bank. The vessel had been mortgaged to secure a loan of about $70 million. The insured value of the vessel was about $55 million, and the loan also secured was also secured by a mortgage over a second vessel. So this is a sort of unusual feature of the claim, or sort of significant feature of the claim when we come on to think about MII, is that the declared value under the MII policy was the value of both of the vessels combined. The bank had taken out mortgagee indemnity interest insurance to cover its interest, covering both of the vessels, for a combined value of $80 million. And the MII policy did not contain a detainment clause in the same form as the war risks policy, so there was a difference. The bank brought a claim under its MII, claiming the full amount of the mortgage debt. And the good guys, the Mii insurers represented by Guy and argued that there would have been no cover under the war risks policy irrespective of the avoidance because of an exclusion, which we'll come on to discuss, and that there could therefore be no cover under the MII. And in any event, we said there had been no loss for the purposes of the MII policy because there was no detainment clause in that form. So that brings me on to the exclusions. The war risks policy was on the Hellenic Club rules. The rules provided cover for detention in the ordinary way, but they excluded losses which arose out of action taken by any state or public or local authority, either under the criminal law of any state or on the grounds of any alleged contravention of the laws of any state. And we can ignore, for present purposes, 3.5.3 and 3.5.4. So these are similar to the exclusions which appear in the Institute War and Strikes clauses, which are here. But they're actually wider for a couple of reasons. So they include any criminal conduct, not just customs or trading regulations. So any actual criminal conduct under 3.51. And if you see the Institute clauses, it's specific to quarantine regulations or customs or trading regulations. And most vessel detentions obviously are likely to involve customs or quarantine or trading regulations, because those are the kind of things that vessels tend to breach, which result in detentions. But there are obviously other types of law which vessels or their crew can breach, which can result in detention. So in one of the leading cases, the Elisa Glacial, illegal fishing by the crew was held not to engage these exclusions because it wasn't a trading regulation. And in this case, there would have been an interesting question, I think, as to whether the oil smuggling was a customs or trading regulation for the purposes of the Institute clauses. And obviously, oil trading or oil smuggling looks like a breach of customs regulation, but the vessel was actually detained under the law against organised crime. So it was an Organised Crime Act offence that led to the detention of the vessel. But anyway, it didn't arise in our case because the exclusion in the Hellenic rules is broader. So that's one difference. A second difference is in the Hellenic Club rules, there is specific mention made of alleged contraventions of the laws of any state. So there's no requirement to show an actual contravention. And similarly, 3.5.1 applies where there's a detention under the criminal law of any state. So if you compare to the Institute clauses, where you have a slightly different formulation, and the Institute wording, it looks like there's sort of two different tests going on. You've got under quarantine regulations or by reason of infringement of any customs or trading regulations. And it's one of the sort of mysteries of the Institute clauses is whether that's intended to produce different results for quarantine regulations and customs and trading regulations, or whether that's just an accident of drafting. And there's sort of some suggestion in the Wondrous that actually there is no difference between those two formulations and they mean the same thing. But I think that's not sort of fully settled. Now, you might be looking at these exclusions and thinking, well, it obviously applies on the facts of our case, surely. But the bank came up with a couple of ways of trying to avoid them. Firstly, the bank argued that they only applied when the owners were themselves accused of breaching the criminal law. And the owner said that these exclusions should be read as a reflection of public policy, that an insured owner can't recover for the consequences of its own wrongdoing. But there are two problems with that argument. The first problem, which might be thought to be an insuperable one, is that it's the same argument that was rejected in the Atlantic. The second problem is that it just doesn't work. It's incoherent because there is, in this case, the exclusion would apply not only to actual criminal conduct, but also to alleged criminal conduct. And it's very difficult to see why there would be any public policy justification for excluding recovery where the owner is wrongly accused of criminal conduct and suffers loss as a result. So that was their first argument, and Mr Justice Calver had no difficulty rejecting that. But it does raise an interesting question, which is what are these exclusions trying to achieve? What is their purpose if they're not following public policy? And I think that is quite an interesting question. There is no sort of easy answer. I think the best answer that I found, interesting to hear Michael's view on this as well in a minute, is that they're trying to identify the type of detention which is intended to be covered by war risks insurance. So the exclusions are used to fence in the type of detention which will give rise to cover, and in particular to bring it into line with the old definition of restraint of princes in the Marine Insurance Act, which referred to, or was understood to refer to, political or executive acts of detention and not judicial acts of detention. So effectively what you're excluding is judicial detention, like the ordinary civil process exclusion, but extended to criminal law as well. Anyway, so that was the bank's sort of first argument, was the owners have to be accused of the criminal conduct. The bank's second argument, which is really what took up all of the time at trial and produced all the Venezuelan law evidence, was that the exclusions don't apply when the detention is unlawful under local law. And in this case, the bank said that the detention had infringed their constitutional rights under Venezuelan law. And this was the point which led to thousands of pages of Venezuelan law evidence and many weeks and weeks of work. But the judge rejected the whole premise of that argument. He said that's wrong as a matter of English law, because a bona fide error, at least in the absence of any sort of perversity, a bona fide error by a foreign court will not prevent detention being under the criminal law of any state or on the grounds of any alleged contravention of the laws of any state. And that's a sort of reasonably orthodox application of the Court of Appeal case called the Anita. And I think there's an interesting question as to whether, I think it's clear from the Anita that an error which is not bona fide will not fall within the exclusion. So a foreign court acting knowingly outside of its jurisdiction will break the chain of causation between the breach of foreign law and the detention. A more interesting question is whether anything short of knowing excessive jurisdiction will do. And the authorities are a bit fuzzier on that. So Mr Justice Flo thought that a decision which was clearly perverse would be enough to take you outside the scope of the exclusion. But that doesn't really emerge very clearly from the Anita. So maybe that's a sort of an argument for another day. But it didn't arise in our case. So that was rejected as well. So where does all this leave us? Well, I think for the purposes of war risk exclusions, if it looks like a duck and it quacks like a duck, it's probably a duck. In our case, it was detained under local Venezuelan criminal law. The exclusions applied, despite the bank's best efforts to argue other ones. And under the institute clauses, there was room for some argument about whether particular regulations could be classified as customs regulations or trading regulations or quarantine regulations. But as you can see, the wordings which are in use by people like the Hellenic Club are drafted to try to avoid those difficult questions, to really try to avoid it. So I think it's in the future, I think it's going to be very difficult in the case of a detention under foreign law to say that the detention doesn't fall within one of these exclusions.
Thank you, Ben. So next up is Guy, who's going to discuss the other aspect of the ZouZou, which was the operation of the mortgagee's interest insurance. Is that right?
Yes. Just before I do, really dealing with Ben's last point, it is difficult to break the chain of causation if there is an error by the judge, the foreign judge, in the application of their law. And the allegation I have seen in both cases I've been involved in, the Be Atlantic and ours, was that there was a political dimension to the case and that the vessel was detained for political reasons, not by reason of the law. In the Be Atlantic, the late President Chavez was said to want a cargo of coal. In this case, it was perhaps even more far-fetched because it was alleged orally, at least, that President Maduro wanted to get his hands on 12,000 tons of fuel oil. So those allegations were rejected, and it is extremely difficult, as you might imagine, to produce cogent evidence of political interference in a country such as Venezuela. And those allegations, factual allegations, were rejected. But moving on to war risks, if you could just move to the next slide. Why do banks take out MII insurance? What can they do under the underlying war risks cover? They can provide that they're loss payees. They certainly won't get any better rights than the owner if they're a loss payee. And indeed, they might face problems with enforceability as a third party. They can become assignees, but they'll get no better right again than owners. They can also become co-assureds and argue that the policy is a composite policy, by which I mean two separate contracts of insurance. But even that can lead to difficulties where, for example, a loss is found to be due to scuttling. And so there was no operation of perils of the seas. It's difficult to see, even if you've got two contracts of insurance, how a bank could recover in those circumstances. So really our understanding, and certainly our case, was that banks look to MII, mortgagees interest insurance, to cover situations in which war risks cover would ordinarily respond, but does not for some reason. In the example I've just given, scuttling. There's very little authority on this class of insurance. It's mentioned in the Captain Panagos. It seems to be clear that the subject matter of the insurance is not the mortgage. So it's not credit risk insurance. I think any underwriter writing this type of cover would be surprised by any contrary proposition. And so the insured subject matter is not the mortgage, which is quite important. This is the interest section of the policy which was before the court in our case. Mortgagee and or lessors and or innocent owners' interest as assignee and loss payee. So the insured interest, and that just means the subject matter insured. I mean, there's a case on that, the Frio Chile, nothing more. The interest that was being protected was the bank's interest primarily as assignee under the policy. And so if you could just flip to the next slide, thanks, Bill. So with this in mind, we said that the first and introductory part of the insurance provision was very important. This insurance is to indemnify the insured, that's the bank, for loss of or damage to or liability arising in connection with the vessel. So a trigger for cover was damage to the vessel, but the insured interest, the subject matter being protected, was the bank's interest as assignee of the underlying war risks policy. And so the premise of all our submissions was, if there's no damage to the bank's interest as assignee, in other words, it hasn't been put in a worse position by anything that's happened than it otherwise would have been, there's no cover. You've got to look to some form of detriment to the bank's interest as an assignee of the war risks cover. Now, the first insuring clause, which, as Ben says, took up about 99% of the time at trial, is fairly orthodox for this type of policy in connection with the vessel, which is prima facie covered by owners' war risks policies. We had quite a debate about what prima facie meant, although that, I think, has now fallen away completely on appeal, perhaps unsurprisingly. The bank ran two cases. The prima facie means you just look at the insuring clauses and not the exclusions, which is contrary to quite a lot of authority and was rejected. Or alternatively, they said that prima facie meant arguably covered. That was also rejected on the basis that that's not what the clause says. But the problem with the bank's case under clause 1.1, as Ben has just said, is that there was no cover under the war risks policy in any event. This clause requires subsequent non-payment by underwriters of the owner's policy resulting from any act or omission. The act or omission here, the alleged fuel smuggling, made no difference because there was no cover under the exclusion, clause 3.5, and because the underlying war risks policy had been avoided in any event. The focus of any appeal that is to be brought, Mr Justice Calver having refused permission, is probably going to be clause 1 Roman numeral 2, which occurs by virtue of any alleged deliberate, negligent or accidental act or omission of any party or any of the relevant parties, which includes just about the whole world, including deliberate or negligent casting away or damaging of the vessel or the vessel being unseaworthy, etc. So what I think you can see immediately is the paradigm case that this clause is aimed at, something like scuttling. But the question arises, who must do the alleging? The bank said, it doesn't matter who does the alleging, any third party can make the allegation of deliberate, negligent, or accidental conduct. And we said no for this reason, because if we are right, as we think we are, that what's being protected is the interest of the bank as assignee, it is only an allegation by owners, war risk underwriters, that could prejudice that interest. An allegation by a third party is it's impossible. It's not going to, in any ordinary case, infringe or prejudice that interest at all. So we said the allegation has to be by war risk underwriters. And there was some support in the policy for that by reference to all of the other insuring clauses. For example, Roman numeral 3, which by virtue of any act or omission or any breach or alleged breach of warranty and condition, that's clearly talking about owners' war risks, underwriters. All of the other clauses, 1, 3, 4, and 5, are triggered by allegations from owners, underwriters. So this would be something of an outlier if it were different. And this was something that Mr. Justice Calver expressed himself pretty trenchantly. On any sensible commercial construction, it's clear that the allegation must be an allegation which is made by owners' insurers, and that the purpose of clause 1.2 is to indemnify the bank where owners' insurers decline cover on the basis of their allegation that loss or damage to the vessel was caused by relevant parties. It is only where an allegation as to the involvement of a relevant party is made by owners' insurers that there will be potentially damage to the bank's insured interest and a loss which can be indemnified by the MII policy. So he didn't find the proposition perhaps to be a very difficult one and agreed with us. And it would be quite a strange clause if the real purpose of taking out MII insurance is to cover a bank when it finds itself exposed for a risk which would ordinarily be covered by war risks, but isn't because of some conduct. We turn on to the next slide. Now, this is an indemnity provision. We said it went rather further than that, a mere quantum provision. The bank said, well, this is tail wagging the dog, placing too much emphasis on this. And you shouldn't try to construe clause 2 that we've just seen by reference to this indemnity provision. The indemnity payable hereunder shall not be determined, etc., but shall be an amount equal to whichever is the least of either the amount not paid under owners' policies by reason of the circumstances specified in clause 1, the total indebtedness, or the sum insured. Now, our argument was, well, 4.1 is not, 4.1a is not restricted in its terms. It should therefore apply to clause 2, Roman numeral 2, that we just looked at. And therefore, the answer in our case is nil. the amount not paid under owners' policies by reason of the circumstances specified in clause 1. In this case, even if the bank was right and the allegation could have been made by a third party, that wouldn't have made any difference. There was no cover anyway. It was excluded by virtue of clause 3.5 of the war risk policy, which in any event was avoided. The bank's argument is that you have to imply a limitation into this clause, and clause 4.1a does not apply to Roman numeral clause 2 because Roman numeral clause 2 doesn't expressly refer to non-payment under the owner's policies. But that's very, very difficult to make out from the wording. Implied limitations are no different to any other implied terms, and could also lead to some commercial, or would lead to some commercial absurdities. You can take an obvious example of a partial loss to a ship, $10,000. If clause 4.1 does not apply, what is the indemnity to which the bank is entitled? The total indebtedness, where the loss has been minor. That can't be right.
Is it worth, sorry to interrupt you, is it worth just briefly explaining how the bank ended up in a situation where they were claiming the full amount of the mortgage debt is because the sum insured in 4.1c was vastly in excess of the total indebtedness because of the sort of peculiarity or circumstance that the MII policy covered 2 vessels.
Yeah, I mean, the claim was for 71 million.
So
and the loss was, on any basis, substantially less than that. But you would get this very strange situation where any small loss would lead to the total indebtedness being repaid, which is not an indemnity. It's a windfall. What the bank said is, well, the principle of indemnity would step in to prevent that. But in truth, what they're trying to do is imply one term and then imply a second term to temper the consequences of the first term. They're either implied terms or they're rules of law. It doesn't make any difference. But it seems a pretty, to us, implausible answer. The other problem with what the bank says about clause 4.1a is if cover under the war risks policy is simply irrelevant, what happens if war risk underwriters pay out? Presumably, the bank is still entitled to have its total indebtedness repaid, which doesn't seem, or didn't seem to us, to be the purpose of the insurance. And this, again, was picked up by Mr Justice Calver. If there was no requirement under clause 1.2 of non-payment by the war risks underwriters, firstly, the bank could recover for losses which never would have been covered. If it is right, and we think it is, that Mii insurance is contingency cover and is intended to be contingent on non-payment under the war risks cover, that is a strange result. The second strange result, the judge said, is the bank could recover a sum far in excess of anything it could ever have recovered under owner's policies, even if the loss had been covered. That's Ben's point, the 71 million point. The bank says, well, we have an insurable interest for all of the sums due under the mortgage. That's section 14 of the Marine Insurance Act, and is doubtless right. But an insurable interest tell you nothing, where, as we say here, there's been no loss at all. Three, the point I've already made, the bank could recover from MII underwriters even where the loss is covered and there's been payment under the owner's policies. So if one simply ignores, as the bank says one should, clause 4.1a, one ends up having to imply a raft of limitations and restrictions to achieve something which would approach the sensible ordinary indemnity. And so that's why we say the bank is wrong. We're right. Mr. Justice Calver has agreed with us. The bank has renewed its appeal to the Court of Appeal. And we'll see where that goes.
So watch this space.
Yes, or not, we rather hope.
Okay. It now falls to Michael to grapple with our final topics for today, and they really are practical issues arising out of the relevance of the constructive total loss, the requirement for notice of abandonment, and to discuss also what, if any, credit has to be given for a residual value of a vessel. Questions which didn't arise in the ZouZou itself because you two did such a good job on liability. So, Michael.
Thank you. Could you pass the
Okay.
clicker? Thank you. Whatever it
I've
is.
lined you up on the right side.
That's very, very kind of you. So yes, I'm going to deal in this last section with a couple of questions that arise in relation to abandonment and notice of abandonment. And one can look at it in a couple of ways. You can look at it just as a question under the war risks insurance, or you can look at it in relation to the MII policy. And those are not necessarily to be approached in exactly the same way. As I understand it, there were issues at trial, at least initially, as to whether or not a notice of abandonment had to be given, not only to the war risks underwriters, but also to the MII underwriters. But at least certainly by the end of the trial, it was common ground that no such notice had to be given to the MII underwriters. The reasons for that, I think, differed between the two parties, and it was all effectively wrapped up with a question as to what was the interest that was insured under the MII policy. Now, I'm not going to deal with that. It's rather complex to deal with in this format, and Guy's already touched on how that works. But I would like to look at a couple of questions. One is, well, how does the detainment clause work in the context of an allegation that there was initially a lawful detention followed by an unlawful detention? Now, this is an argument that's been raised before in a couple of previous cases, but it has always failed. One of the reasons is that touched on by Ben at the beginning, which is that the way in which unlawful detentions work, or rather don't work, is that you have to go beyond something which is merely unlawful. It has to be unlawful in a sense that perhaps is perverse, such that it breaks the chain of causation. So if one is looking at a situation where there is a lawful detention developing into an unlawful detention, you always have to look for something which merely goes beyond, say, a court getting it wrong. And you are probably looking at something plausibly in relation to political interference, as Ben has already mentioned. Ordinary detentions are generally excluded. So you're looking at something which is probably political interference or something like that. Now, one could have a situation where initially it was a regular detention, but it could then develop into something where there was some form of perverse interference, perhaps political. So the question would be, well, how do these clauses work? Because as you'll see from the detainment clause, you've got effectively two provisions. One says that you can't bring a claim for a CTL until 183 days. So in other words, you've got 6 months, you can't bring a claim. And then if you have deprivation for 12 months, you are then deemed to have been deprived of possession without any likelihood of recovery, which satisfies the statutory test, or at least part of the statutory test for detention. Now, how does this clause apply in relation to a situation where you have a lawful and then unlawful detention. Well, the clause itself doesn't refer to the underlying cause of the capture, seizure, arrest, restraint, detention, etc. It doesn't say, for example, that the underlying cause must be a peril insured against. So it doesn't say that this clause is applicable or inapplicable if the detention has come about because of an excluded cause. So is it to be read as impliedly as only applying where there is a peril insured against, which has led to the detention? Now, there wasn't really very much of an analysis in the judgment in the ZouZou, because effectively the claimants lost on the facts and lost quite badly on the facts. So they didn't even get to the point of showing that the detention was unlawful, let alone that it was perverse. And indeed, as I understand it, they hadn't even suggested that that was the case. But how would this apply? Well, I think the two subclauses need to be looked at separately. The 12-month detention provision, all that does is deem the owners to have been deprived of possession without any likelihood of recovery. That's all it does. It doesn't say, and there is a claim for CTL. And the reason why it doesn't do that is because it doesn't have to do that. If you want to bring a claim for a CTL, you go to the statutory test. You have to show that it has been detained, that you have been deprived of possession by an insured peril, because that's what the statute says. And then you have to show that there is an unlikelihood of recovery within a reasonable time. And it's only the last part that this detention clause actually deals with. So you have to take second part of this clause and then plug it into the statutory test. And then after 12 months, you effectively get your deemed CTL, but only if it was a detention as a result of an insured peril. So there doesn't need to be any reference in this clause to whether or not there is an insured peril involved, because the statutory provision provides that requirement. Now, that's the second part of the clause. But what about the first part of the clause? The first part of the clause says you can't bring a claim for CTL or your 6 months are up. Now, not all detainment clauses contain this prohibition. Some simply contain the second part. But if it has the first part, this is a prohibition on bringing a claim for a CTL. Does that only apply where the detainment is due to an insured peril? Or does it apply where the detainment is for some excluded cause? Now, if one looks at the function of this, the function of this is to prevent claims being brought. It's completely unnecessary to exclude a claim for a CTL if the cause of the detention was something which is excluded. So again, it's difficult to see how this would apply in the absence of detention for something that was actually covered. So if it's an excluded peril, then it's not needed and it's irrelevant. So one then gets a situation where there could be a detention for a period of for a lawful cause, and time won't start to run. So that if you have this provision, could be detained for 6 months. If it then becomes unlawful in the relevant sense, i.e. political detention, it's only then that the 6 months will start to run. So the insured wouldn't be in a position to say, well, 6 months have already passed. I'm now into the second part of the clause. time would only start to run once there is an insured peril. It's rather different if you were just bringing a claim under the statutory test in the absence of such a provision. If you were doing that, you probably could bring into account the time that has elapsed before the detention becomes unlawful in the relevant sense, but only if that prior detention was relevant to what might happen in the future. So it'd have to be relevant to looking at whether or not the vessel will be recovered within a reasonable time. So that's the abandonment and notice of abandonment CTL under the war risks itself. Of course, where one has a mortgagee interest policy, the abandonment will never have taken place. One will have a purported abandonment to the war risks underwriter. It will be rejected, and the insured owners will continue to have possession of the vessel. Now, the absence of any notice of abandonment under the MII policy actually has quite an important practical consequence. And that is because under the MII policy, the underwriters, if they have to pay out, will have to pay out the amount that was not paid by the war risks underwriters. So if there is an ordinary case of non-excluded peril, but for some reason, maybe non-disclosure, there is no payment out. So we have the MII policy being triggered. You'll have a situation where the bank will claim the insured value. But what about the vessel itself? The vessel is not an actual total loss. It's only a CTL, and it can have considerable value. Now, in the ZouZou, as I understand it, the value of the vessel at the time of notice of abandonment was some 21 million. And the MII underwriters argued that some credit had to be given. If they were to lose, and of course they didn't lose, but if they had lost, they said that there would have to be a credit given for that 21 million. And the reason for that is that if the MII policy is going to mirror what would have happened under the war risks insurance, then there ought to be a mirroring of this giving credit for the value of the vessel. Now, the problem is that the MII policy only comes into effect if there is no abandonment. There is, in fact, no abandonment. There's no transfer, in fact, of the vessel to the war risk underwriters. And under the policy itself, the MII policy, the insured is entitled to payment of what would have been paid under the war risks policy. And under the war risks policy, there would be no payment by the insured to the war risk underwriters. What happens as a matter of law is that the vessel is abandoned to them. Now, in practice, of course, war risk underwriters don't actually take the vessel. They get a credit. But in order for that to be relevant under the MII policy, you would have to somehow construe the indemnity, which was in relation to the amount not paid by the war risk underwriters, as somehow factoring in that credit. And it seems to me that this is something where the MII insurers would seriously struggle. The policy seemed to be pretty clear. There are no rights of subrogation. The MII insurers under their policy are subrogated to the rights of the insured, but they're not entitled to exercise the rights that the war risks underwriters themselves would be entitled to exercise under their policy. And so there does seem to be a big lacuna in the way in which the MII policy fails to mirror the war risk insurance. It's not something that was dealt with in the judgment, because when it came to quantum, the judge had obviously had enough in deciding what he'd already decided. And so he simply said that that doesn't need to be dealt with. But it does seem that there is quite a serious lacuna in that case, to the tune of 21 million.
That's the next case we're going to have.
That's the next case.
So in terms of questions and answers online, we've had a few, but they've been answered. So I'm going to throw open to the floor. Anyone here present would like to ask the question? Everyone here is saying please don't, but feel free. Yes?
I had a question for Guy, and afterwards maybe a question for Michael. For Guy, in two parts. First of all, can we have the wording of something to roll one back, please?
Michael?
Oh, yes.
Because if I read it right, one of the things it covers the mortgagee against is misrepresentation or non-disclosure.
Yes.
So the fact that the war risks insurers had avoided the policy is something against which the mortgagee is insured under the MII policy.
Under 1.1, yes.
And then
We didn't get there because there was no prima facie cover.
yeah, well, prima facie cover, it did seem to me that it was getting a bit complicated. I mean, one paradoxical result seems to be that if the owners deliberately use the vessel for smuggling, then the mortgagee is covered. But if the owner's vessel is seized by the authorities without the owner's involvement, then the mortgagee isn't.
I don't think
No,
is correct.
I don't agree.
I don't think
either.
that's correct. I think that's really a question about numeral 2 rather than numeral 1.
Yeah.
But
Well, any act or omission?
Well, yeah, but you've got to start with prima facie coverage if there is an infringement of the criminal law, irrespective of whether owners were or weren't involved. Then there's no prima facie cover. So you may have broad words relating to non-disclosure, but you don't get there.
Well, I think one thing that occurs to me is simply if I look back, I would think that this was a result I hadn't expected. But the other thing is, what I don't understand, you may be able to tell me, is why prima facie isn't construed as opposed to resulting from. In other words, covered except because of the act or omission.
yes,
I think that's right, but I mean, the starting point I think has to be that the purpose of MII insurance is that it responds where, for some reason, something has prejudiced the position of the bank under the war risks cover. You have to have prima facie cover, and then which results from, as you say, subsequent non-payment resulting from the example you gave, non-disclosure. But if you have no prima facie cover in the first place, then the non-payment doesn't result from the non-disclosure, because there would be a non-payment anyway, and no causative effect.
yes. So I think our case in a nutshell is, or was, where you have a type of loss which would never have been covered by the owner's policies, you cannot have cover under the MII, because there is no loss to the bank, to the bank's insured interest, which is its interest in the owner's policies, because those owners' policies would never have responded anyway.
Yeah, it's the words, there is subsequent non-payment resulting from. There isn't subsequent non-payment resulting from. There's subsequent, because there's no causal connection. There's no cover at all anyway. So they did not pay simply because of avoidance, they would never have paid anyway.
Yeah. So I think that it's a more sort of difficult question in some ways in relation to 1-2, because I think your sort of smuggling example is where the rubber meets the road in relation to 1-2. But the answer to it on the judge's analysis is to say, well, the involvement of the crew is irrelevant to the fact that smuggling is not covered by the owner's policies, because smuggling would never have been covered. So it doesn't matter whether the crew are alleged to have been involved or not alleged to have been involved. It's simply a type of loss which would never have been covered under the owner's policies.
And I think that now is probably beyond argument to the contrary, because you've got the B Atlantic at first instance Hamlin, you've got a specific agreement with Lord Mance in the Supreme Court, you've got other cases to that effect as well, but I think it's not going to be changed. Privity or otherwise of the owners is an irrelevant consideration.
Can I ask a question going back a stage to the war risks cover? I mean, Ben, you pointed out that the Hellenic war risk rules were much broader than the standard clauses in terms of the exclusions. I mean, it very much depends on each individual war risk policy, doesn't it? Because I've seen a number of different policies. They have slightly different wordings. It'd be lovely to be able to take the ZouZou and say, yes, this is exactly the same, but the wordings change. But it's probably, in my experience, more frequently that they don't use the standard wording now. Is that your experience, Ben, Guy?
Yeah, I mean, the clubs don't use the standard wording. The syndicates tend to. We did see a very brief appearance of the famous malicious acts. That was pleaded for a while, and malicious acts now means some spite or ill will, recklessness against property following B Atlantic doesn't suffice. So that came and went pretty quickly. But yes, I mean, there's quite a lot of bespoke wording at the club level. Is that your experience too, Michael? Having written the war risk book, you've seen a few war risk policies and the exclusions. So yeah.
I mean, insofar as it relates to MII, it's an interesting question because the MII wording has a warranty that the owners will maintain standard form of other machinery war risks, P&I insurance. So if you have a deviation which prejudices the insurers, then that's an interesting line of argument for the insurers in connection with coverage. Yeah. But on the fact of this case, obviously, that it was a more generous exclusion for the insurers than for the so it's sort of, it benefited us rather than hindering us. Yeah. Okay, well, the topics for discussion may have been prompted by the ZouZou and Venezuelan smuggling, but I think that everyone sitting here today know that owners, mortgagee banks, lawyers and underwriters don't need to look very far to where we're going to find other detainment type cases in the future. So fortunately for them and us, having listened to our panel, I think we're in a much better position to answer the questions that we're going to get. And I'd just like to say thank you to Ben, Guy and Michael for their interesting insights today. And for those of you who are here in our library, hopefully we're going to have some refreshments. So I'd be delighted if you could join us. And before we do, can I just conclude today by saying I hope you all enjoyed it as much as we did. And we look forward to welcoming you to Quadrant Chamber's next event, which will be after the summer. Thank you.